Our last case this morning is 2019-1494, Wayne L. West et al. Versus C.J. Bode et al. For the appellant, Mr. Bean. Counsel, if you unmute your microphone.
May it please the court, Chief Justice O'Connor, Justices of the Supreme Court of Ohio. If I may, I'd like to reserve 5 minutes for rebuttal. And this case arises out of a case in Monroe County, Ohio, in which there was a complaint with one claim for relief, and that was under the Marketable Title Act, and it was filed in 2017. After the paper discovery was done in the pleadings, there was cross motions for summary judgments, and the Common Pleas Court of Monroe County granted summary judgment stating that the 530156, the Ohio Dormant Mineral Act, and the Ohio Marketable Title Act were in irreconcilable conflict. That was then appealed to the Court of Appeals, which reversed that decision and remanded it back for further application of the Marketable Title Act. The statement of facts, and I'll be very brief, with the mineral chain, there's a mineral chain of title here, which comes through an auditor's deed in 1944 to the appellant's father, Nova A. Christman. And that granted 1/2 of the royalty in place to John L. Christman, Catherine Hasselberger, and Charlotte McCoy. There are title transactions resulting from that, and there was a 1977 notice of preservation, and there were certificates of transfer in Mr. Christman's estate put on in 2017. Therefore, however, the issue that we're here on this morning is the issue of the conflict between the Ohio Dormant Mineral Act and the Ohio Marketable Title Act. And it is the position of the appellants and the amicus briefs filed on our behalf by Ascent Resources and Gulfport that those two statutes are irreconcilably in conflict. And the reason being that the standards in the two statutes are different. If you take the standard for the Marketable Title Act, it extinguishes the interest that there is no title transaction within 40 years in a person's chain of title. However, the standard for the ODMA, which is part of the Ohio Marketable Title Act, is different. And so you could have different results on the same facts. In my opinion, that's an irreconcilable conflict. For instance, in the Ohio Dormant Mineral Act, their savings events are different. The production of minerals will keep the production of minerals, gas storage, permits for mineral production, or the existence of a separate tax identification number. These are all savings events under the ODMA. And also by the filing of different preservation notices, it allows the purpose behind these statutes to be, and that is that you look at one chain of title and you can find out if, in fact, who the owner of the oil and gas is.
Mr. Bean, can you direct us to any language in the Dormant Mineral Act that would explicitly say this is intended to be the exclusive set of remedies?
I think that Your Honor, I think that the language is that there. I can't direct you to its exclusive remedy language. However, the thing is, this part of the statute evolved from this court's holding, Justice French, in Hefner versus Bradford in 1983. And what that did, it recognized that there could be two chains of title, and that any title transactions in that independent mineral chain of title, and that was an oil and gas case, would defeat a Marketable Title Act claim. So this statute, I believe, was put in place in 1989 to allow a person to look at this and say that it would simplify and facilitate land title transactions, especially to mineral estates. Because if not, you would have to do a patent to present day. But that also was addressed in the Bradford case, in which the court said the period of search is something for the legislature. But to answer your question precisely, I can't really say that I can say, well, this statute supersedes the other, except it was later in time, and therefore it appeared that it was needed to do that. Also, there's as stated in Ascent and Gulfport's amicus briefs here, there's almost 500,000 acres of oil and gas, and they could be producing these wells and those leases and get hit with the Marketable Title Act. This hinders the stated purpose that in Ohio that we are to develop our mineral estates safely and promote that. And by adding assurances and stability to these type of transactions, you're promoting the development of the natural resources in Ohio, and especially in eastern Ohio, that has, from the whole time I've been practicing, and 100 years before that even, is dependent upon minerals. And we've done mineral searches from coal now through the oil and gas boom because of the shale thing. And therefore, looking at the statute, and this court has cited it many times, in 151, if there's two statutes and one specific and one is general, the specific one will control unless the general was later in time, and etc. Here, with those type of situations where you could get different results on the same set of facts, you're not promoting the policies of Ohio's by causing mineral owners to have to go out and take what's called top leases just to be sure that they're not going to be hit with a claim. And therefore I believe that the facts of this case clearly show that there is an irreconcilable conflict between the statutes. And I'll reserve the rest of my time.
Thank you. Mr. Regal.
Chief Justice O'Connor, may it please the court. My name is Ryan Regal, and I'm here on behalf of the Appellee Surface Owners Wayne and Rusty West. Justice French, to piggyback off the question you had asked opposing counsel, I would answer no, there's nothing in the text anywhere between the MTA or DMA that says that the DMA is the exclusive remedy. I would go so far as to say not only does the text not support any position that the DMA is the exclusive remedy, I would say in addition to that, the legislative history supporting both the MTA and when the DMA was added to the MTA, as well as all of the case law that has arisen from and since the MTA was enacted back in 1961. Essentially, the sole issue before this court is to determine whether revised code 5301.56, which is also known as the DMA, supersedes and replaces the MTA. Essentially, Appellant's argument is that they would ask this court to completely ignore the MTA as it relates to mineral interests. And again, like as I said, I think the text of the statute and the legislative history completely deem that argument meritless. Broadly speaking, these two statutes really, I think it's important that we both look at these statutes as what a severed mineral interest owner is to do to preserve interest under these statutes, not what a surface owner must do to get rid of these interests. No court of appeals in this state or in any other state has said who have both a Marketable Title Act and a subsequent procedural remedy to abandon a mineral interest have ever said that abandonment statute precludes you from using the Marketable Title Act in that state.
Would you at least agree that it does make it a lot more difficult? I mean, if the whole purpose of the Dormant Mineral Act is to make this simpler, facilitate title transactions, how does applying both of the acts serve that purpose?
I think it all depends on the specific facts of your case. And I think back in 1961, when the legislature had enacted the MTA, it specifically excluded mineral interests. So realizing that there was a reason or a need for a statute to effectively allow surface owners to get rid of old stale interests, that's why they had added in 1973, they amended the MTA to include mineral interests in that statute to allow surface owners to do that. As opposing counsel had mentioned, a lot of people say that the Heifner case was the reason for the MTA because it says the MTA does not extinguish interest in all cases. So I think the MTA was added as a supplement to the MTA to effectively make it easier in those situations where a title could get complicated. But again, there's nothing in the statute that ever would deem a irreconcilable conflict between the two because there are two different statutes that apply in two different situations. As this court has determined in the Corbin case, under the DMA, specifically the 19 DMA, this court has determined that a deemed abandonment is completely different than an extinguishment that would have occurred under the MTA. The plurality opinion and Justice Kennedy's concurrence both have agreed that there's a distinguishment in the terminology and how both statutes operate. The test here, though, in this case to determine one or the other is really rooted in the revised code 1.51. And I want to read that statute because I don't think the opposing counsel has technically properly conveyed what the test is in that statute. Revised code 1.51 specifically expresses that if a general provision conflicts with a special or local provision, they shall be construed, if possible, so that effect is given to both. If the conflict between the provisions is irreconcilable, the special or local provision prevails as an exception to the general provision, unless the general provision is the later adoption and the manifest intent is that the general provision prevail. Again, our position is there is no conflict between the MTA and the DMA. Again, they are separate alternate statutes with separate and distinct mechanisms for determining whether a severed mineral interest is valid. Therefore, in our opinion, no analysis is required under 1.51 because there's no conflict. But again, not only if there's a conflict, even if there is a conflict between the two statutes, you still have to, according to that statute, apply them and try to give effect to both of them. And only if that conflict is irreconcilable does that specific statute apply over a general statute. As I discussed just a couple seconds ago, this court in Corbin has determined that there's a difference between a deemed abandoned interest and an extinguished interest. Under the MTA, there's an extinguishment. Under the DMA, there's an abandonment. The test under the MTA, there's a 40-year period where you have to determine, based off all record chain title, things that are in the public record, that was in accordance to when the MTA was enacted. Look for a 40-year period. If nothing has happened in that 40-year period, or none of the exceptions apply, by operation of law, that interest is extinguished. That interest is then determined to be null and void, and there's no reviver or possibility of reviver of that interest. Under the DMA, because as I said before, the Heifner case has kind of said, hey, in not all situations will the MTA be successful in getting rid of this interest. Let's try to, I assume that the General Assembly wanted to try to make it easier and add another tool to the surface owner's belt to get rid of those stale interests. So therefore, under the DMA, the procedure there is a 20-year period where it results in an abandonment based off of lack of use. And that results in a deemed abandoned interest, and there is a possibility of reviver after a mineral interest owner would receive a notice of abandonment. There's no reason or anything wrong with General Assembly essentially if enacting two different statutes and to apply to mineral interest. Any argument to the contrary is simply a policy argument. Just because the standards are different and in applying both of the statutes, that's not a irreconcilable conflict, and there's no case law that would support that position. Any differences between the results that may result in the MTA or the DMA, that's a policy argument that should be left to the legislature to decide. And again, I think in my position, the legislative history and the text of the statute show how both statutes actually and how the General Assembly intended for them to operate and coincide with each other. For example, under the DMA, under C3, if a severed mineral interest owner would like to preserve an interest, they can file a claim to preserve. If you look at that statute in the text of the statute of 5301.56, it says that what the requirements are, and it refers you back to a part of the MTA as far as what it has to comport with and what it has to comply with. Under 5301.52, that then refers you back to a preservation notice statute in the MTA. So again, this General Assembly, based off just the mere text of the statute, show that they intended for both of them to apply. Again, only when the conflict is irreconcilable does a specific proceed over a general. Giving the fact that they provide for different procedures for the existence of a different statutory right or remedy, again, does not mean it irreconcilably conflicts with the DMA. Again, the different results don't show that they are in conflict. It just shows that they're different. Each applies to a particular situation, independent of the other. And in the briefs of both the appellants and the amicus in support of the appellants, there is no attempt by either of those parties to reconcile the two statutes, which again is required by the plain words used in revised code 1.51. Again, in speaking with how the MTA applies and how it operates, the MTA automatically obviously extinguishes severed mineral interest by operation of law and does not, as appellants have argued in the brief, extinguish things outside the chain of title. In being able to utilize the MTA, the chain of title and the public records are specifically used, number one, to determine the chain, number two, to determine a root of title deed, and to determine if there's any certain references or exceptions that would prevent one from using the Marketable Title Act. It did not frustrate the purpose. The MTA does not frustrate its own purpose. Essentially, in 1961, the purpose of the MTA was to simplify and facilitate land title transactions. If the argument is that the MTA itself, by applying to mineral interests, frustrates that purpose in 1961, and at least no later than 1973, when it specifically applied to mineral interests, it would have been inherently flawed. So there's no merit to the argument that the MTA in and of itself frustrates its purpose and prevents that from being able to be applied. And it's ironic that when the appellants discuss in their briefs that things happen under the MTA that would occur outside the chain of title, again, why I would oppose that, it's the DMA that actually operates on things that are outside the chain of title. For example, if you look at the 5301.56B3B, it talks about actual production. That's not something that would appear in the chain of title. If you talk about underground gas storage, that's not something that appears outside the chain of title. Those things, it's in other words, what my argument is that the MTA is solely based on the chain of title and the records present in the recorder's office or in the public records, not that the DMA is actually different. So in Corbin, when they discussed the difference, and this court discussed the difference, and there's the difference in terminology and meaning, I think that it would have been true that if the DMA was self-executing, it would have operated outside the chain of title. The MTA is completely different in that that's all it's solely based and relied upon. Again, this court just recently applied Blackstone, applied the MTA to a severed mineral interest. Now, that was a severed royalty interest, but again, it specifically applied. And in doing so, in its purview, in this court's purview, there was in the lower court, an account for the DMA and account for the MTA. So again, this court specifically has established that the MTA was still applicable in that situation. So essentially what the appellant's position is that that case should never have happened because the MTA doesn't apply. I just want to touch base also on a few arguments that were raised in the appellant's brief that aren't necessarily applicable here. They raised the due process argument, which I believe is well briefed in our positions, in our briefs, and the amicus that were filed on our behalf. But the AG, the Ohio Attorney General, was never added to a party, and that issue was never raised at the lower level. So I think essentially that has been waived. And I want to kind of get into how the MTA in this case particularly applies and why it's our position that the MTA has extinguished the severed royal interest that happened. So to go back to that, I would like to just briefly talk about the specific facts of the case. So my clients acquired the property in 1996, but in 1902, there was a severed interest of a 1/2 oil and gas royalty. There were some minor conveyances that got eventually to 3 different individuals. By doing the title work and finding out and determining what the root of title deed for my client's property, it was determined that there was a 1959 certificate of transfer. So by identifying that as a root of title deed, you're identifying the 40-year period to have marketable title. That would have left you with a 1959 to 1999 time period to look forward to and determine whether anything happened within that time period that would prevent you from extinguishing the interest under the MTA. Appellants argue that there is a claim that was filed in 1977. However, that was outside the chain of title. The appellants coincide and argue that it's like the Heifner case where there was something outside the chain of title and the oil and gas chain of title was also separate. That's true in this case. However, the difference in this situation that there was in Heifner, there was a direct connection between when that reservation was initially made to the parties who had filed that claim to prevent within that 40-year period. In this case, we don't have that same thing. We don't have that same situation. In fact, we have the initial reservation in 1902 with some conveyances in between, and then there's a break in the chain of title of the oil and gas chain of title. And as a result of that, that is why no one, even in looking in the chain of title of the surface or in the oil and gas, would it have been discovered that the auditor's deed had existed or that the claim to preserve would have been filed. So again, just to recap, I think this court has already issued the Blackstone opinion, which is good law and should apply in this case, that the MTA is still an applicable procedure. The analysis under revised code 1.51 is, and it's our position, there's no conflict because there are 2 different statutes that get you 2 different results. Even if there is a conflict, no such conflict is irreconcilable, as the 7th District has shown that they can be reconciled. So it's our position that even under the revised code 1.51, the test fails. And again, Heifner is similar to this case in which they applied, but when the legislature enacted the 1989 DMA, they weren't just doing that to make that the sole remedy, because there's nothing in the statute that says that. They were doing that to add an additional tool that surface owners could utilize to help surface owners get rid of stale, old, unused interest. And I see that I'm nearing the end of my time, and I would just like to thank the court for the consideration.
Thank you. Thank you. Mr. Bean. Mr. Bean, if you'll unmute your mic.
Starting with the last argument is by Appellees. It's completely contrary to even their amicus brief in the Ridenour amicus brief, which says that there is no question that the title transactions in the separate chain of title under Heifner versus Bradford are title transactions, and therefore the appellants are not bound by the Marketable Title Act in this case. That's their briefs, and he said that over and over again. And that's true. If you look, there was a 1977 preservation notice that complied with the law in 1977, and there were certificates of transfer from Mr. Chrisman's estate to his children's estate in 2007. So that argument is taken care of not only by our briefs and the briefs, but also by actually the amicus brief of Ridenour in favor of the appellees. But also, what a conflict, the conflict here is that you have a specific statute aimed at only oil and gas. And that specific statute tells you what you have to do in order to have that ownership transferred. Not a defect in title, nothing. An ownership transfer has to be done pursuant to the provisions in 5301.56. Those provisions are there. It goes not only on the standards, but if you look at these standards and the notices that go out, you can actually preserve your interest in your ownership interest because you own the mineral. It's a separate chain of title under Heifner. You can preserve that interest by putting on a notice of preservation within 60 days of notice to you of the notice of abandonment. And it's specific to oil and gas. That's why they're in irreconcilable conflicts. Whenever you can have those standards and they come out with a different result, that is an irreconcilable conflict. Also, you're talking about staying within the chain of title. The chain of title that the appellees like to talk about is the chain of title to the surface. Whenever you have multiple estates, i.e. mineral and surface, you have more than one chain of title. And what the ODMA does, it facilitates the production of oil and gas by saying if there is going to be an abandonment or an extinguishment of the oil and gas, it has to be done through 5301.56. And these notices that go out to the landowner. They go out and they're in the landowner's chain of title. Otherwise, it's like the case at Bar. There's no notices in there. And because there's the separate chain of title. We've dealt with that and for many, many years in Ohio with coal, because coal has a separate chain of title. And after Hefner, so does oil and gas. So they are in irreconcilable conflict. And the legislature, by coming on and putting on the ODMA in 89, and then in 2006 amending it with the notice provisions, recognized that and recognized the chain of title, and I think clearly by implication, they recognized that the Ohio Marketable Title Act was not the proper remedy to end mineral estates and to cloud titles in Ohio. Thank you.
Thank you. Thank you, gentlemen. We will take the matter under advisement and you'll be notified of our decision. Marshall, will you adjourn court, please?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.